want to welcome you all to meeting 19 of the Legislative Committee on Bill C-30. We're now going to embark on the detailed clause-by-clause consideration of Bill C-30. 66 amendments have been received by the clerk at the end of last week. These were packaged into a binder and distributed to members first thing on Monday morning, March 19th. One additional amendment was received from the NDP after the binders were sent out, and this has just now been distributed this morning. Earlier this morning, we received 34 amendments from the Liberal Party, which we are advised are to replace the Liberal amendments currently found in your binders. These have been copied, and I believe you have been given them.
Clarity, Chair. The 34 new Liberal amendments, did you say replace?
Are replacing the amendments that were in the binder that you were given on Monday. Is that correct? Yeah.
So all the amendments that we've been reviewing that the Liberals submitted are no longer...
Are replaced by the new package that you just got. Mr. Moffat.
Mr. Chair, the departmental staff don't have the most recent amendments.
They're making copies now. I had to make sure members have it.
They're making more copies as we speak.
Thank you.
Okay. Mr. Jean.
I would suggest, Mr. Chair, that it's very important for all of us in the room that the department receives that. Excellent. I see they do have it, yeah. So that they can provide any advice we need.
They've got them now. I mean, we're all dealing with these at the moment.
I wouldn't mind a little explanation from our colleagues as to why, with very firm timelines and dates that we've pushed back, that they scrap all amendments and then bring a whole bunch of new ones. It speaks of ill faith in the negotiations of this, how we can table drop 34 new amendments today, many of them substantive and large, blowing the deadline that we had all agreed to. This committee had all agreed to, including the members from that party. So I think an explanation is in order.
A lot of time was spent, I'm sure, by all of us on the committee reading in earnest and the implications of each of the amendments, and so that we're ready today. And now, as we arrive to receive another 34, it creates a big problem for this committee moving forward. We do have commitments made to move forward, and I hope this is not another delay tactic that we're seeing from the Liberal Party.
I do apologize, of course, to committee members for this, because these are new developments, but they're not 34 new amendments. They're really two big new amendments with consequences for numbering and so on. Most of those consequences will be delayed to future meetings because of where they occur. And so the only one that really, I think, affects today's discussion is the insertion of the concept of the Commissioner for Environmental and Sustainable Development, which we've discussed at length in this committee.
So if this Commissioner of the Environment in particular, this new amendment that you've brought today, is that meant to be early on in the bill? And was it your intention for it to be heard today?
That's right, Mr. Speaker. We think that the logical place for it is early on in the bill.
And sorry, just to be clear, was it meant to be heard and discussed today?
Yes. Yeah.
Well, this then, Chair, is a critical moment as a tone for setting this committee. We've attempted to be upfront. We all agreed upon rules. I'm looking at your ruling when we decided how amendments would be brought. And the suggestion that a substantive amendment, we heard testimony about the Commissioner of the Environment many weeks ago. This did not happen in the last few days. The consideration, while it may be valid, of adding into C-30 this consideration, to drop it on the day of and expect committee members to then discuss and cast votes on this is irresponsible and can be seen as a form of delay. That there's just no substantive way to look at this and say we're going to bring a substantive amendment that we had heard testimony some weeks ago, and suddenly we want committee members to address it and vote on it today, change Canadian law, change the role of the Commissioner of the Environment. We're going to give you 5 minutes to look at it. I think that's irresponsible on the part of my colleagues in the Liberal Party, when we've been trying to work in a spirit and environment of cooperation and forthrightness. My goodness, the NDP tabled our amendments in November. It's totally unacceptable.
What I would like to know is this. We have this major amendment, and what I would like to know is whether or not there are other amendments that may have an impact on that binder of amendments that we have in front of us. Because then we have an even greater problem. We have a technical problem because we're going to have to make all of these amendments consistent with those changes, and we're not in a position to be able to do that. We have not analyzed the amendments that have been put forth. So
we're now into a substantive debate without the motion having been moved. This is the problem with dropping things on the table at the last minute, is that there's no consideration for the clerk's staff or the legal counsel to know whether something is receiving a royal rec, so we're making decisions essentially on the fly, because we've only just seen this 5 minutes ago, as has the staff.
We all are here to move forward on Canada's Clean Air Act, and yet what we've seen now is 9 or 10 pages of legal text provided to the committee on one amendment. And what's been the result of that? We're now an hour into this meeting. We've installed, and I don't know if it was deliberate or not, but the results have put this committee into a quagmire and made it very difficult to move forward.
Changes a substantial portion of what I consider to be one of the greatest offices in Canada, and that is they're asking for an amendment to the Auditor General Act. I don't know, I don't have a copy of the act in front of me. I understand, and I quote Section 51.1, Section 15.1, to repeal of the Auditor General Act is repealed. Now, I mean, they're putting this forward, Mr. Chair. I think it's beyond the point of ridiculous at this stage. 3,000 words of text that we have to get 3 minutes to review, plus amendments to other acts, which, quite frankly, the Auditor General Act is one of the most important cornerstones of independence that we have in this Parliament. I just think it's ridiculous at this stage.
My ruling now on this is that it does require, sorry, thank you, that it would require royal assent because it is establishing a new office under, that's right, I'm sorry, royal recommendation, because it does establish a new office under the Parliament of Canada Act, and thus requires new spending, thus requires a royal recommendation, and I would therefore rule that it's inadmissible.
I have an alternate amendment I'd like to move that does not require the spending of any funds beyond what is already provided for in the given authorities. And if I could distribute that, I have copies available and translated into French.
Mr. Dean?
Mr. Chair, here we have another, at 10:10, we have another amendment put forward by the Liberals. I mean, the sham and the sideshow here is clearly evident.
We have to get copies of this amendment. The amendment is being submitted in accordance with the rules, however distasteful that may be to some.